Thank you for being here as we announce an action to address a crisis that has been decades in the making right here in Los Angeles County. It's a crisis in the Los Angeles County jails that we will not allow to continue. For years, incarcerated individuals have been subjected to inhumane conditions and systemic neglect. Today, following a comprehensive investigation by my office, we're filing a lawsuit against the following people and parties: the Los Angeles County Sheriff's Department, Los Angeles County, Los Angeles Sheriff Robert Luna, and County Correctional Health Services and its director, Dr. Timothy Belovich, for ongoing violations of state and federal law that deprive people in custody of their basic rights. Let me be clear, this is about human dignity, this is about safety, this is about justice for those who are in our care. Los Angeles County operates the largest jail system in the United States and one of the most problematic, unfortunately, where ongoing failures put countless lives at risk every day. These conditions aren't new. For decades, the county has been aware of the unconstitutional conditions inside its jails. Yet instead of taking responsibility and fixing the problems, they've resisted oversight. They've spent millions of dollars defending lawsuits, fighting change instead of embracing it, and failed to implement reforms they themselves agreed to go through, through consent decrees and prior litigation. So they're already been sued. They've already been sued multiple times. They're under multiple consent decrees to implement changes. Even given the lawsuits, even given the consent decrees, they still haven't implemented the needed change. Now, just to be clear, the fact of the need for change cannot be in dispute. The sheriff has stated that change needs to happen. He's acknowledged the conditions that need to change. Others have said the same. Independent reviews and reporters have indicated that it is essentially a humanitarian crisis inside the LA County jails. Yet we are here today because the LA County Sheriff's Department, instead of making the changes, wants to fight, knowing that they need to make the changes. They want to spend taxpayer money on litigation, on fighting, on resisting, on foot dragging, instead of making the changes that are necessary. To this day, conditions inside Los Angeles County jails are still inhumane, and they include some of the following: filthy and unsafe facilities with broken plumbing, with infestations of rats and roaches, and inadequate access to drinking and bathing water. Basics. They include spoiled, moldy meals, little to no access to basic hygiene supplies, including soap and toilet paper, menstrual products, and unsoiled clothing and bedding. Nearly constant confinement in cells, which contributes to both physical and mental deterioration. And inadequate or delayed medical, dental, and mental health care, leading to preventable injuries, suffering, and, yes, deaths. When we're talking about feces smeared on the walls and medical care denied to those in need, we're talking about a disrespect for the basic dignity of our fellow humans and a violation of their most fundamental constitutional rights. Healthcare failures in these facilities are so severe that one of the county's own oversight bodies has called it, as I mentioned before, a humanitarian crisis. Right here in Los Angeles, in county jails, the Sheriff's Department, the Sheriff, LA County know about it, and they're not making the changes. Unacceptable. And most alarming, people are dying. In the last 4 years, there have been more than 206 deaths inside the jails, and more than 40% were caused by preventable circumstances, including suicides, homicides, and overdoses. 85 human beings lost their lives unnecessarily. And these numbers continue to rise. Over the years, county leadership has repeatedly directed the Los Angeles County Sheriff's Department to strengthen narcotics enforcement inside jails and conduct more comprehensive searches of staff and of visitors, yet overdoses and deaths persist. Just this past May, the Board of Supervisors directed Sheriff Luna and Dr. Belovich to investigate the causes behind the rising number of deaths in Los Angeles County jails. But they continue to drag their feet to the detriment of far too many. We can't wait any longer. We need comprehensive reform, and we need it now. And that's what this lawsuit is about. My office has worked collaboratively with other law enforcement agencies, and we've done this across the state to address systemic failures. And we've seen meaningful reform where agencies act in good faith, partner with us, collaborate, work together to accomplish a goal and solve a problem and implement the needed reform. That's the way it should be. Unfortunately, that is not the case here. So we're left with no choice but to sue and seek injunctive and declaratory relief that would require Los Angeles County to do the following: to provide constitutionally adequate medical, dental, and mental health care, protect incarcerated persons from unreasonable risk of harm, maintain safe, humane, and habitable conditions, respect the dignity and the health of incarcerated individuals, ensure health care requests are addressed promptly and fully, provide reasonable accommodations and equal access to services for people with disabilities, and ensure access to language services for those with limited English proficiency. I'd prefer, to be clear, I'd prefer collaboration over litigation. But the county has left us with no choice, so litigation it is. We've seen as recently as last month what happens when law enforcement agencies proactively work with our office to improve. In Torrance, the city and the Torrance Police Department sought an independent review after deeply concerning misconduct among officers. They reached out to us. They knew they had a problem. They were right, and they reached out to us to help solve it. Together, we established a set of enforceable reforms to address our publicly reported findings, and the city agreed to have its implementation of these necessary reforms overseen by an independent monitor to improve accountability, policies, and community trust. That's the way to do it. And we were in this very room not long ago with Torrance's police chief announcing that reform, that path forward, that collaboration to acknowledge problems and confront them and fix them together. That's the way it should be. Where Torrance stepped up, Los Angeles County has stood still. They've refused to meet even the most basic constitutional standards. That's why we also recently had to ask a court to put in place a receivership over Los Angeles County's juvenile halls, because they too, rather than make progress on the needed reform, have stood still, and unacceptable conditions remain there as well. So make no mistake, my office will continue to step in to protect vulnerable populations and ensure meaningful reform when necessary. And it is necessary here in Los Angeles County in the Los Angeles Sheriff's Department. Today's lawsuit is just one example of that commitment and of that promise. We know that reform is achievable when agencies engage in good faith collaboration, but we won't hesitate to go to court when they refuse to act. The Los Angeles County Sheriff's Department has refused to act, and so we are in court. While the Los Angeles County Sheriff's Department made some improvements to its policing practices during the course of our investigation, these have primarily come from the county's compliance with other court orders. And these haven't put an end to the unsafe and unconstitutional conditions that continue to persist in its jail system. So I do want to acknowledge there have been some improvements in some areas, mostly on patrol, and those are important. We acknowledge them. We're grateful for them. That is the right path forward. But there has not been nearly enough progress with respect to the jails and the conditions of confinement, which means that after years of engagement, we're left with no choice but to go to court to make these necessary changes happen. There are still unsafe and unconstitutional conditions that continue to persist in the jail system. That cannot continue. It will change. It must change. Our lawsuit will be the driving impetus to make those changes reality. And we didn't take this step lightly, but when lives are at stake and decades of inaction have caused preventable suffering and preventable deaths, we must act, and we will act. And today, we do act. Every community deserves law enforcement that upholds, at a bare minimum, constitutional standards. That's the floor. Every person in custody deserves safety, health care, dignity. They deserve conditions that will prepare them to re-enter society and provide rehabilitation for those serving sentences. This benefits all of California. This lawsuit is about accountability, it's about transparency, it's about justice, and we are here to ensure basic rights, fundamental rights, are upheld. As California's Chief Law Enforcement Officer, I'm committed to ensuring that every Californian is treated with care, dignity, and protections they deserve, regardless of their custody status. And so that's what this lawsuit is about. I'm grateful for my team getting us to this point. I'm happy to answer any questions in a moment, but before I do, I want to acknowledge and thank the team members in my office that got us to this moment, working hard, working overtime on behalf of the people of California, and making sure that we have constitutionally compliant, legally compliant conditions in LA County here in the Sheriff's Department, which we do not yet have, but with our lawsuit we will. And I want to thank Yasmin Manners, Caitlin Weisberg, Tanya Sukija Cohen, Dominique Alcaraz, Joshua Piovia Scott, Shirley Sullinger, Cherokee Melton, Srividya Panchalam, Virginia Corrigan, Michael Newman, Daniel O'Bannon, Damon Brown, and so many others that have worked on this investigation over the course of the years. LA County is the largest county in the nation. This is a big sheriff's department. It's the largest in the nation. And so we've been digging in, reviewing and investigating to get to this point, and we have emerged with this very important complaint in state court to make sure that the necessary changes are made. And with that, I'm happy to answer any questions that you might have. Hi. Yeah, and would like to and happy to answer any on-topic questions as well, but let me talk about that. I know it's top of mind for so many, including us in the California Department of Justice, who, as you know, we were an amicus in the underlying case here in the Central District of California, in which that the ACLU led, and in which a trial court judge found that it violated the Fourth Amendment for ICE agents, federal immigration officers, to use race, the inability to speak English, location, or perceived occupation, to use those factors in any one of them or in any combination to stop and detain, search, seize Californians. And I agree with that case. I thought it was well written, well supported by the law and the facts. And the federal government, of course, appealed that case, and the Ninth Circuit did not grant the federal government's request for stay. But then they went to the Supreme Court on what's called, the U.S. Supreme Court, on what's called the emergency docket. And today we got word that on the emergency docket, on a 6-3 decision, it appears the U.S. Supreme Court has stayed, provided an emergency stay on this case. And so it's disappointing. And the emergency docket has been used more and more. You often don't know who has voted how, and for what reason. There's no argument. There's no written opinion. There's no statement by judges as to justices regarding where they stand and why they stand where they do. We did get a little glimpse into some thinking with a concurrence by Justice Kavanaugh on the emergency opinion, as well as a dissent by Justice Sotomayor, joined by Justices Kagan and Brown, and so Jackson, excuse me. And so we don't know the reason that the 6 judges decided on this. We may never know. But we do know, because he told us, Justice Kavanaugh's decision. And it's very disturbing. And I think Justice Sotomayor sort of captures where it leaves us if you follow Justice Kavanaugh's decision, again, which might not be the majority's rationale. And she says, we ought not live in a government or in a nation where the government can seize you because you appear Latino, because you speak Spanish, or because you appear to have a low-wage job. And I couldn't agree more. We shouldn't live in a country like that. And that's what the lower court's decision was about, making sure that we don't live in a country like that. And we'll see what happens next. This is, an emergency petition. The U.S. Supreme Court could have stayed out of it and allowed the lower court proceedings to continue, but they decided that they wanted to weigh in. I'll also acknowledge that the U.S. Supreme Court has recently said that you can't consider race in college admissions when it could be one factor among many to tackle historical discrimination, to address personal racial discrimination in an applicant's life. You can't consider it. But you can consider race when in a city like LA, where there are so many Latino Californians lawfully present, following the law. You can use race as a factor to discriminate potentially against Angelenos and Californians based on race. So how they prevent the use of race to tackle discrimination but allow the use of race to potentially discriminate is disturbing, and it is troubling. So those are some of my thoughts on the opinion.
AG Bonta, bias photo coming from Rob. Does your office plan to take any steps to address the Supreme Court's order in the court that issued this way?
We're not a party in that case, so it'll be up to the party to decide. We will monitor. We will use appropriately our role as an amicus and consider doing that again should there be a response to the stay. But of course, the U.S. Supreme Court is the highest court in the land, and so their decision is it's an emergency stay while the proceedings continue. It's not a final decision in the case, an ultimate decision in the case. There's more of the case to continue. But we will observe what the parties to the litigation decide to do in court, and should we have a role that we think is helpful and appropriate as an amicus, we will consider that, certainly. Thank you.
Were you surprised by that ruling or not?
Surprise these days is pretty relative. Disappointed. I think the rationale articulated by Justice Kavanaugh is dangerous and wrong, but he's a Supreme Court justice and I'm not. And I don't know if he represents the majority of the court on this issue, but he really went out of his way and wanted to make sure people knew his thinking, and so we know it, and it's dangerous. And obviously, as I've said before, I continue to have a strong belief in and a commitment to the rule of law. It's non-negotiable for me and for us here at the California DOJ. We'll uplift it and defend it. We follow court orders. And this wouldn't be the first time that in a case that we had or any party had, you've won below at the trial level, you've won at the intermediate appellate level, and maybe you don't get the answer that you want at the Supreme Court level, but we follow court orders because that's the appropriate thing to do in the United States of America. We're not talking about impeaching any justices or calling anyone a so-called judge or questioning the court's ability to opine. It is their role. They have taken a role. We will respect it. But it's disappointing. I wouldn't say surprised, but I will certainly say disappointed. Any other questions? All right. Thank you for joining today.